Hello, I'm Andy Falls, and I will be describing my observation of a courtroom proceedings from the perspective of a juror. A few years ago, I was summoned for federal jury duty where I served on a criminal case. The potential juror veneer was escorted into the courtroom. The defendant was seated in the courtroom at the table of the defense, which was initially startling, however understandable as to why the defendant has a right to be present during jury selection. Voir dire then began. The judge asked questions regarding occupations, personal relationships with police officers, and affiliation with the National Rifle Association. After each juror answered the question at hand, the prosecutor and the defense attorney would have a sidebar with the judge, and the judge would excuse people for cause. The entire selection took place in about an hour, and 12 jurors and 2 alternates were selected and sworn in. The charges against the defendant were read: a felon in possession of a firearm. The jury was given instructions and charged with the task of finding the defendant innocent or guilty beyond a reasonable doubt. The trial then began immediately. The U.S. attorney made his opening statements. The greatest surprise in the case came from the law itself. Per federal law, a felon may not knowingly possess a firearm. However, for the felon to be subject to this law, the firearm must also have been transported across state lines sometime before it came into the felon's possession. The U.S. attorney had the burden to prove the elements of the case beyond a reasonable doubt. He had to show that the defendant had possession of the firearm and said firearm had been transported across state lines. It was acknowledged that the defendant was a convicted felon. The defense attorney then made his opening statement, which simply reiterated the 2 elements of the case that had to be proven beyond a reasonable doubt. The U.S. attorney called witnesses that began with the 2 arresting officers who had stopped a car on a routine traffic stop in which the defendant was a passenger. Both officers gave their credentials and their years of employment with the San Diego Police Department. One of the officers stated that he did not recognize the defendant as he looked really good and had gained about 25 pounds. Obviously, much time had passed since the defendant had been arrested. In the officer's next statement, he mentioned a knife had been discovered in the car. The defense attorney immediately objected. The judge sustained the objection and directed the court reporter to strike the statement from the record. Evidence in this case had been suppressed. The next witness was a DNA analyst who described exactly how she processed the firearm and extracted DNA from the handle as well as other points on the gun. The defendant's DNA was indeed found on the handle of the firearm. She went on to explain other parts of the evidence processing. However, she was unable to explain it at a layperson level, and many on the jury did not understand. During cross-examination, the defense attorney asked the witness many leading questions trying to demonstrate that his client's DNA could have come in contact with the gun without the defendant physically touching the gun. While some of the testimony may have been too technical for the jury to understand, the expert witness provided enough understanding to show the defense attorney did not seem to understand much on the DNA evidence himself. This was a crucial mistake for the defense attorney, who needs to have a strong understanding of the science being presented. The final witness for the prosecution was an ATF agent who described how he had followed the gun through databases and phone calls from being manufactured in California to being sent to a distributor in Iowa and then sent back to California for sale, where the gun was legally sold to a consumer. During cross-examination, the defense asked if the agent had gone to Iowa and inspected the records himself. The agent had not. The defense attorney tried to insinuate that this was enough reasonable doubt the gun had crossed state lines. The prosecution rested their case. The defendant did not testify, and the defense called no witnesses. The defense then rested their case. The closing arguments from both sides were almost identical to the opening statements and were fairly anticlimactic, a stark contrast to this often being the most dramatic aspect of a trial. The jury deliberated for about 2.5 hours, and the defendant was found guilty of being in possession of a firearm. A few questions came to mind from this courtroom experience. First, what caused the knife in this case to not be allowed into court as evidence? Was the knife obtained in a way that was unlawful, or was the processing of the knife as evidence somehow compromised? Second, was this defense attorney weak, or was the case against the defendant very strong? Finally, where are the defendants taken during court recess and lunch breaks? When court adjourns for the day, the defendant is transported back to jail. The jury left the courtroom for breaks and recesses, but only saw the defendant sitting at the defense table. There are 2 actions that can be incorporated into practice. First, be very detail-oriented and follow protocol to the letter when collecting evidence. Too many cases have evidence thrown out due to human error associated with not following protocol. Cross every T and dot every I. Double and triple check the work. Second, when testifying before a jury, write in crayon. Make sure the technical description used in court is simplified to a level understandable and relatable to the jury. In conclusion, much was learned from observing the proceedings in the courtroom concerning the law, courtroom procedure, and civic duty. Thank you, and I look forward to your comments.